Have you ever stopped to really think about the hidden legal rules that shape so much around us? I mean, things like how huge family fortunes are kept safe over generations, or, how tricky disputes get sorted out when the strict rules just don't seem fair.
Yeah, when the black and white law doesn't quite fit.
Exactly. It's this fascinating area where fairness, justice really steps into the spotlight, even if the law itself might point another way at first glance. So today, we're taking a deep dive into that very world, the intricate, sometimes really surprising, but absolutely vital realm of equity and trusts.
And for this exploration, we've gathered, well, quite a range of sources. We've got excerpts from legal texts like Equity and Trust with questions and answers, course guides, some really insightful academic papers.
Right.
And we're weaving those together with key case law that's really defined this area over, well, centuries.
Our goal today is pretty straightforward. Cut through the jargon, the legalese, and really unveil the core ideas, the surprising insights that make equity such a powerful force in law today.
Think of it as a shortcut, maybe, to understanding a really important part of the legal landscape that often gets overlooked.
Okay, let's unpack this. So, to really get what equity is, we kind of have to step back in time. Because it didn't just appear out of nowhere, right? It came about because common law had a problem.
That's exactly right. Historically, common law could be very fixed, very rigid, and sometimes, honestly, that led to unfair results.
That's just harsh outcomes.
Yeah, harsh outcomes where people were left without a proper remedy. Imagine a situation where sticking strictly to the rule actually caused an injustice that's precisely where equity found its purpose.
So equity wasn't just a minor tweak. It was more like a different approach layered on top, often called a gloss on the common law.
A gloss is a good way to put it.
Yeah.
Its whole point was to bring in fairness and justice where those strict common law rules were failing.
But how did it actually establish itself? How did it gain traction?
Well, it developed slowly, mainly through the courts of chancery. They focused on the conscience of the individuals involved. And over time, you had these key figures who really shaped it.
Like who?
Well, there's Lord Nottingham, people often call him the father of equity, foundational work.
Okay.
Then Lord Hardwicke helped lay down more general principles. And later, Lord Eldon sort of consolidated the rules. This made the system more predictable, more precedent-based.
Ah, so it became more like common law in that respect. Predictable.
In a way, yes. It developed its own body of rules and precedents, even while aiming for fairness.
And that leads to a really core difference, doesn't it, between common law remedies and equitable remedies?
Oh, absolutely vital distinction. So at common law, if someone breaches a contract, you can claim damages as of right. You prove the breach, you're entitled to compensation.
Right.
But equitable remedies, like, say, specific performance, where a court actually orders someone to do what they promised in the contract.
Not just pay up, but actually perform the act.
Exactly. Those are always discretionary.
Yeah.
The court decides if it's fair and appropriate in that specific case. It's not automatic.
Okay, that's a massive difference. And this is where it gets really interesting, because equity also works based on these fundamental principles, these maxims, like guiding stars for the court.
That's a great analogy. They're like ethical compasses. Let's talk about a few. One big one is equality is equity.
Equality is equity. What does that mean in practice?
Well, it embodies fairness in how things are distributed. So, for example, if people own property together, equity often presumes they hold it as tenants in common, meaning they each have a distinct share.
Rather than joint tenants where the survivor takes all.
Exactly. Equity leans towards separate shares. It also guides courts towards equal division if there's no clear instruction otherwise. And it's fascinating. You mentioned Uganda. Their legal system actively uses this maxim against joint tenancies and that right of survivorship based on their Succession Act. It's quite a specific application.
Interesting. Okay, another powerful one. Equity will not permit a statute to be used as an instrument of fraud. That sounds, well, quite bold.
It is bold. It really shows equity's power. It means equity can look past legal formalities if someone's using them dishonestly.
So like using a loophole for fraud.
Precisely. For instance, the Law of Property Act generally says trusts over land need to be in writing. But if someone tries to use that rule saying, it wasn't written down, to actually commit fraud, equity can step in.
It says, no, we see what you're doing.
Exactly. We won't let you use the law itself to cheat someone. It prioritizes preventing unconscionable behavior.
So it's about the spirit, not just the letter of the law. Okay, then there are these two related ones. Equity will not assist a volunteer, and equity will not perfect an imperfect gift. What's the takeaway there? No freebies in equity.
Pretty much. A volunteer is someone who hasn't given consideration, they haven't paid or given something in return for a promise.
So just a promise to give something for free?
Right. Generally, equity won't enforce those gratuitous promises. And if someone tries to make a gift but doesn't complete all the legal steps to transfer it, equity usually won't step in and finish the job for them. The gift remains imperfect.
So if I say, I'll give you my watch, but never hand it over, equity won't force me.
Generally, no. You're a volunteer, the gift is imperfect. But there are exceptions.
Always exceptions.
Always. A key one is the Natura Mortis Causa gifts made in contemplation of death, deathbed gifts.
Right.
There's a case, Woodard v. Woodard. A father was terminally ill, gave his son his car keys, basically said, you keep these, I won't be driving anymore.
Oh, okay.
The court said handing over the keys in that context changed the son's role from just holding the keys, maybe, to being the intended recipient, the dunny.
Yeah.
It validated the gift, even without formally signing over the registration then and there.
Because of the specific circumstances and the intention.
Exactly.
Yeah.
Equity looked at the substance, not just the strict form.
That's a great illustration. Okay, moving from these guiding maxims, the real heart of equity for many people is trusts. But let's clarify. How is a trust different from something like, say, a bailment, just holding something for someone?
Good distinction to make. Bailment is limited to chattels, movable things like jewelry, a car, equipment, and the duties involved are mostly based on common law rules.
And the owner can lose their rights more easily.
Potentially, yes. The bailer, the owner, might lose legal ownership through things like estoppel, for example.
Okay, so how is a trust different?
Trusts are much broader. They can cover any kind of property, land, shares, money, intellectual property, you name it.
Not just physical things.
Right. And the trustee's duties are equitable duties. But here's the crucial bit. A beneficiary's interest under a trust is really quite secure. It can generally only be defeated if the legal title is transferred to it's a bit of a mouthful.
Go on, let's hear the mouthful.
A bona fide purchaser for value of the legal estate without notice of the equitable claim.
Okay, wow. Break that down. Bona fide.
In good faith. Acting honestly.
Purchaser for value.
They paid for it, didn't get it as a gift.
Legal estate.
They got the full legal ownership, not just some lesser right.
And crucially, without notice.
Meaning they genuinely didn't know and couldn't reasonably have been expected to know about the beneficiary's hidden equitable interest.
So it's a very high hurdle to jump over to defeat the beneficiary's rights.
Extremely high, designed to protect the beneficiary strongly. Unless someone is that genuinely innocent, good faith buyer, the beneficiary's claim survives.
Got it. That's real protection. Okay, let's look at different types of trusts. The general rule is a trust needs human beneficiaries, right? It can't just be for an abstract purpose like promoting world peace.
Generally, no. Trusts need someone who can actually go to court and enforce them. But there are major exceptions.
And the biggest one is?
Charitable trust, definitely the most significant exception.
Right, because they benefit the public, not specific people.
Exactly. And because there are no specific beneficiaries, the Attorney General steps in to enforce them on behalf of the public. The Charities Act 2006 updated the definition, but that core idea of public benefit is still key.
Can you give examples?
Sure. Things like advancing health. There was a case, Rishi's Will Trusts, that said even hospitals charging fees could be charitable if their main aim was public health. Or trusts for specific places, like in Rees Smith, a gift to My Country, England, was held charitable.
But it has to be charitable, not just generally good.
Precisely. Compare that Rees Smith case with Houston v. Burns. A gift for public, beneficial, or charitable purposes failed. Why? Because public or beneficial aren't automatically charitable in the legal sense. It's a specific legal category.
And charities can't be purely political, right?
Correct. They can advocate for policies related to their charitable aims, but their fundamental purpose can't be political campaigning.
Okay. Are there other exceptions besides charity? I think I saw something about Reed Denley.
Ah, yes, the Reed-Denley exception. It's another way a purpose might be valid. It applies if the purpose provides a direct, tangible benefit to a clear group of people.
So not abstract, but benefiting actual individuals.
Exactly. The classic example is land given for a sports ground to be used by the employees of a company. The purpose benefits an identifiable group directly.
Is that a bit of a loophole then?
Not really a loophole, more a specific, limited exception. The benefit has to be concrete, not too vague, and the group of people needs to be ascertainable. It doesn't open the floodgates for any purpose trust.
Understood. Okay, another key distinction. Discretionary trusts versus fixed trusts.
Right. A fixed trust is straightforward. The person setting it up, the settler, spells out exactly who gets what and when. For instance, divide the income equally between my 3 children. The trustees have no choice. They just follow the instructions.
Clear instructions. And discretionary.
That's where the trustees do have a choice. The settler defines a class of potential beneficiaries, say, my employees and their dependents, and gives the trustees the power, the discretion to decide who within that class gets something and how much.
So they have power, but do they have to use it?
Ah, good question. If it's just a power, technically they don't have to distribute anything, although if they're a fiduciary, they must at least consider exercising it. But if it's a discretionary trust, the trustees must distribute or accumulate the income. They have to exercise their discretion. They just get to choose how.
That's a subtle but important difference. Must exercise versus must consider. And this ties into how certain you need to be about who the beneficiaries are, right? There's a big change here.
A huge change. Before a landmark case called McPhail v. Dalton, discretionary trusts needed the same level of certainty as fixed trusts. You had to be able to potentially draw up a complete list of every single beneficiary.
That sounds impossible for large groups, like huge company pension funds.
Exactly. Cases like IRC v. Broadway Cottages Trust showed how difficult that was. Many large trusts, especially pension trusts, would have been invalid. McPhail v. Dalton changed the game.
Ow.
It adopted a more flexible test, the same one used for powers. The is or is not test, or any given postulant test. You just need to be able to say with certainty for any person who comes forward whether they are or are not a member of the class of beneficiaries.
You don't need the full list, just a clear definition of the group.
Precisely. This saved countless large trusts, including the very one involved in the McPhail case itself. It was incredibly important practically.
Yeah, you can see why. Okay, next up, resulting trusts. These sound like they result from something, unintended consequences.
They often arise where the law presumes an intention. They're often implied rather than expressly created. Maybe someone transfers property to someone else without receiving payment. The law might presume they didn't intend a gift, so a resulting trust pops up, meaning the recipient holds it for the original transfer.
So it bounces back.
Kind of, yes. Now, there's been some debate about the theory, do they arise automatically, or is it always about presumed intention? Lord Brown Wilkinson in the Westdeutsche case strongly argued it's about presumed intention.
Even if earlier cases seemed more automatic, like for anonymous donations to a disaster fund that failed, re-Gillingham.
Yeah, right. The prevailing view now focuses more on what intention the court can infer, even if it contradicts some older ideas about automatic resulting trusts in specific scenarios like anonymous donations. It's a bit theoretical, but impacts how courts approach these situations.
And within resulting trusts, there's this thing called the presumption of advancement. Sounds a bit old-fashioned.
It is, somewhat. It's a counter-presumption.
Yeah.
In certain relationships, traditionally father to child, husband to wife, if money or property is transferred, the law presumes it was intended as a gift, an advancement.
So the opposite of a resulting trust in those cases.
Exactly. It presumes a gift instead of the property resulting back. But note that traditional limitations didn't typically apply from wife to husband or mother to child, reflecting historical assumptions about who had the moral obligation to provide.
Has its relevance faded?
Courts are more cautious now. One case, McGrath v. Wallace, called it a judicial instrument of last resort. It can still be relevant, but it's easily rebutted by evidence of the actual intention.
Like in that Secon v. Alyssa case, where the mother transferred property to her daughter partly for tax reasons, but still got a resulting trust back.
Right. The court looked beyond the alleged tax motive and found evidence she intended to keep a beneficial interest. It also brings up tricky issues around illegal purposes. Cases like Tinsley v. Milligan and Tribe v. Tribe explored whether you can rely on an illegal scheme to establish your claim. Generally, you can't, but it depends on whether you need to plead the illegality itself.
Complex stuff. Okay. Shifting from presumed intent to imposed fairness, constructive trusts. These sound like the court actively builds a trust where one wasn't intended.
That's a good way to think about it. They are imposed by law, regardless of anyone's intention, usually to prevent fraud or unconscionable conduct. If someone gets property through, say, undue influence, the court might say, you hold that property on constructive trust for the person you wronged?
I remember hearing about Lord Denning's new model constructive trust. What was that about? Did it stick?
Ah, Lord Denning's bold idea. He suggested a constructive trust should arise whenever it was simply inequitable for the legal owner to keep the property solely for themselves. A very broad, justice-seeking approach.
That sounds reasonable.
Maybe, but it was decisively rejected by the higher courts, like the House of Lords in Gissing v. Gissing. They felt it was too uncertain. Lord Dipla clarified that constructive trusts typically arise only where the legal owner induced the claimant to act to their detriment based on a belief they'd get an interest. It requires more than just general unfairness.
So specific conduct and reliance.
Yes, induced detrimental reliance.
And this comes up a lot with shared homes, right? Unmarried couples, property in one name.
Hugely complex and common area, yes. Interestingly, while Denning's broad approach for finding an interest was rejected, courts do seem to adopt a more flexible, fairness-based approach when deciding the size or share of the beneficial interest once it's established one exists. Midland Bank v. Cook is an example.
So strict rules for if, flexible rules for how much.
Something like that. Lord Bridge in Lloyds Bank v. Rossett emphasized that finding an interest based on an agreement needs evidence of actual express discussions about ownership. Relying on conduct alone, like renovations, usually requires significant detrimental reliance directly linked to the belief of ownership. It's a high bar.
Okay, so equity can imply trusts, presume them, construct them. What about deliberately hiding them? Secret trusts. This sounds intriguing.
They are definitely intriguing. Secret trusts operate outside the usual will formalities. The Wills Act, 1837, requires wills to be written, signed, witnessed. Secret trusts are an exception, allowed primarily to prevent fraud.
Fraud? How so?
Imagine someone leaves property to a friend in their will, looking like an absolute gift. But secretly, they told the friend, "Hold this money for my secret lover." If the friend then tried to keep the money, saying the will gives it to me absolutely, that would be fraud. Equity steps in.
To enforce the secret promise, are there different types?
Two main types.
Yeah.
Fully secret. The will looks like an absolute gift, no mention of a trust. Half secret. The will says the property is held on trust, but doesn't specify the beneficiaries or terms those are communicated secretly.
Okay. What do you need for these to be valid? Seems risky.
It is. You need three things. One, intention. The testator must have intended to create a trust. Two, communication. They must communicate that intention and the actual terms of the trust to the secret trustee.
When does communication have to happen?
For a fully secret trust, anytime before the testator's death. For a half-secret trust, it must be before or at the same time the will is made. But telling them the terms after the will is signed isn't good enough for a half-secret trust.
Okay, intention, communication of terms. What's the third?
Acceptance. The secret trustee must accept the obligation. This can be express agreement or even tacit acceptance, like staying silent when told about the trust obligation, as in Ottaway v. Norman. Silence can imply consent.
That's fascinating. Sailing under sealed orders, as one case put it?
Exactly. Riekien used that analogy for communication via a sealed letter given to the trustee before death. And just being told you are a trustee isn't enough communication of the terms, as Rebois showed.
Does it matter if these are considered express trusts or constructive trusts?
Yes, it matters quite a bit, mainly for formality rules. If they're constructive, then, for example, the usual requirement that trusts of land must be in writing might not apply. An oral, fully secret trust of land was upheld in Ottaway v. Norman. If they're expressed, the writing requirement would likely apply. It's still debated.
Right, formalities again. Let's switch focus to the trustee themselves. Being a trustee sounds like a big responsibility. What's the core principle? The fiduciary position.
Absolutely central. Trustees are fiduciaries. This means they have an overriding duty, a really strict duty, to act solely in the best interests of the beneficiaries.
Solely, even if it's tough.
Even if it means making decisions that are legally right, but maybe morally difficult, like in Bull v. Saunders. Their loyalty must be undivided. Like a doctor to a patient, their interest comes second to the beneficiaries.
Okay. Do they get paid for this? It sounds demanding.
Traditionally, no. The default position is that trustees act voluntarily. But in practice, almost any professionally drafted trust will include a charging clause, allowing trustees, especially professional ones, to be paid for their time and expertise.
Makes sense for professionals. What standard of care do they owe? Do they have to be investment gurus?
The old common law standard was that of an ordinary prudent man of business managing their own affairs. Reek Whiteley. The Trustee Act 2000 updated this. Now there's a statutory duty of care, which to exercise such care and skill as is reasonable in the circumstances. But crucially, the Act imposes a higher standard on professional trustees, or anyone holding themselves out as having special expertise.
So if you're a bank acting as trustee, you're held to a higher bar than, say, a family friend.
Exactly. More is expected of professionals.
What if they mess up? Can they hide behind clauses in the trust document saying they're not liable? Exemption clauses?
Trustees can have exemption clauses, but courts construe them very strictly against the trustee. Critically, you absolutely cannot exclude liability for fraud or deliberate wrongdoing.
What about just being negligent or grossly negligent?
That's trickier. The leading case, Armitage v. Nurse, suggested you could exclude liability for negligence, even gross negligence, as long as it wasn't dishonest. But later cases like Bogg v. Raper and general legal opinions suggest excluding liability for gross negligence is probably against public policy now. It's a fine line, but you can't get a free pass for everything short of outright fraud.
Okay. And they have powers to actually manage the trust,
Yeah.
given by law.
Oh yes, numerous statutory powers under the Trustee Acts and other legislation like the Trusts of Land and Appointment of Trustees Act 1996. Powers to invest, insure, delegate, sell property, appoint agents, tools to help them administer the trust effectively.
What about the beneficiaries? Do they get to see what the trustees are doing, see the accounts, the trust documents?
You'd think so, right?
Yeah.
An absolute right. But it's actually more nuanced now. It used to be thought beneficiaries had a proprietary right to see trust documents.
But not anymore.
The Privy Council decision in Schmidt v. Rosewood Trust Ltd. changed the thinking. It said, no beneficiary has an absolute right to disclosure. Instead, it's part of the court's inherent jurisdiction to supervise trusts.
So the court decides.
Yes. The court will consider the beneficiary's request, weigh it against factors like confidentiality, personal or commercial, the nature of the beneficiary's interest, and decide whether disclosure is appropriate. It's discretionary, not automatic.
Balancing transparency and privacy. Okay, let's move beyond the structure of trusts to equitable remedies. We know they're discretionary, but let's look closer at some key ones.
Right. Always discretionary. The court considers all the circumstances.
First, specific performance, making someone actually do the thing.
Exactly. Ordering a party to perform their contractual obligations. Usually only granted if damages wouldn't be an adequate remedy, like for unique goods or land, and generally requires the claimants to have provided full consideration, varnishing consideration.
But there was an exception you mentioned, for volunteers.
Yes, an interesting wrinkle. It can sometimes be granted if a volunteer is already in possession of land they were promised. The idea is it might be unfair to take the legal estate away from them then. But generally, it's not granted for contracts needing ongoing co-supervision. Courts don't want to manage people's performance long term.
Right, too messy. What about rescission, undoing a contract?
Precisely. It sets the contract aside, aims to restore the parties to their original positions, often because of things like mistake, Cooper v. Phibbs, or misrepresentation. It basically voids the contract ab initio from the beginning.
And it's related to rectification, fixing mistakes in documents.
Related, yes. Rectification corrects a written document that doesn't accurately reflect the parties' agreed terms due to a mistake. But you need clear evidence of the mistake and the continuing common intention, Rose v. Pym. Rescission undoes the deal. Rectification fixes the paperwork.
Okay, injunctions. Probably the best-known equitable remedy. Tell us about the main types.
Well, you have interim injunctions that used to be called interlocutory. These are temporary orders granted early in a case before the full trial to preserve the status quo.
To stop something potentially harmful happening right now.
Exactly. The court applies the American Cyanide Guidelines. Is there a serious question to be tried? Where does the balance of convenience lie? Who suffers more if the injunction is or isn't granted? And usually, the claimant has to give an undertaking in damages.
Promise to pay if they were wrong to ask for it.
Right. Protects the defendant if the injunction causes loss and turns out to be unjustified later.
And then there are those dramatic-sounding freezing injunctions, Mariva orders.
Yes, very powerful. Designed to stop a defendant from dissipating their assets or moving them out of the country to avoid paying a potential judgment.
Like hiding the money offshore.
Exactly that kind of scenario. Lord Denning laid down guidelines. The claimant needs a strong case, evidence of assets within jurisdiction, a real risk they'll be removed or dissipated, and again, that crucial undertaking in damages. Full and frank disclosure is also vital when applying for one.
Can a court award damages instead of an injunction? Seems odd for equity.
It can, yes, under the principles from Shelfer v. City of London Lighting. If the injury to the claimant is small, can be estimated in money, can be adequately compensated by a small payment, and it would be oppressive to the defendant to grant an injunction, then damages might be awarded instead. It's a pragmatic exception.
Okay, another really powerful tool, tracing, following the funds.
Or following the property. Tracing is the process of identifying your property, or its value, as it changes hands or form. It's crucial when trust property has been wrongfully taken or mixed.
But it depends on the property still existing in some form.
Yes, the value has to be identifiable. And there's a distinction between tracing at common law and in equity. Common law tracing is quite limited. Generally, you need legal ownership to trace at common law. MCC proceeds case.
So beneficiaries usually need equitable tracing.
Correct. And equitable tracing is more flexible. It can follow property through mixed funds, for instance. If a trustee mixes trust money with their own and buys shares, equity allows the beneficiary to claim the shares, or at least a charge over them for the amount of trust money used. Re-Hallett's estate.
What if the mixed fund bought an asset that went up in value?
Fosca v. McEwen is key here. The beneficiary can choose. They can either claim a proportionate share of the asset or enforce a charge against it for the amount of trust money used. They get the benefit of the increase if they claim a share.
So they can choose the best outcome for them. Smart. Now, what about compound interest? You mentioned a big shift there.
Yes, this was quite revolutionary. For a long time, based on Westdeutsche Landesbank, it was thought compound interest on interest in equity, was mostly reserved for breaches of fiduciary duty, like a trustee misusing funds.
Simple interest otherwise.
Generally, yes, or for common law claims. But then came Semper Metals v. IRC. The House of Lords basically said, hang on. If someone has wrongfully had the use of your money, why shouldn't they pay the full-time value, including the interest they could have earned on the interest?
So making the defendant pay back the real benefit they got.
Exactly. It allowed compound interest to be awarded in restitutionary claims at common law, too, not just for fiduciaries in equity. It recognized the economic reality that money makes money, a huge shift in calculating compensation for the wrongful withholding of funds.
Shows how equity can influence the common law, too. Okay, let's wrap up with a few other key doctrines that show equity's reach. The doctrine of conversion sounds alchemical.
A little. It's a legal fiction where equity treats land as money, personality, or money as land, realty, in certain situations, usually dictated by a will or trust directing a sale or purchase.
Even if the sale or purchase hasn't happened yet.
Yes, that's the fiction. So if a trust directs land to be sold, equity treats the beneficiary's interest as an interest in the future money, not the land itself. Legislation like the Trusts of Land and Appointment of Trustees Act 1996 reduced its scope, but it's still relevant for express trusts and on intestacy sometimes.
Does it apply to just regular contracts to sell land too?
Yes. Once you have a binding contract to sell land, equity imposes a constructive trust. The seller holds the legal title on trust for the buyer, and the seller's interest is notionally converted into personality, the right to receive the purchase money, Hillingdon Estates.
And there's a weird rule about options to buy land. Laws v. Bennett.
Yeah, it's considered anomalous but well established. If someone grants an option to buy their land, and they die before the option is exercised, but it is exercised later, the conversion relates back to the date the option was granted. So the sale proceeds go to whoever inherits their personality, not their realty. Strange, but that's the rule. Resuiting deceased.
Equity has its quirks. Okay, doctrine of satisfaction, paying off debts with legacies.
Kind of. Based on the maxim, equity imputes an intention to fulfill an obligation. If someone owes a debt, and then leaves a legacy in their will to the creditor, equity might presume the legacy was intended to satisfy the debt.
So the creditor can't claim both the debt and the legacy.
That's the presumption. But it only applies if the legacy is equal to or greater than the debt, and there aren't other factors suggesting the legacy was meant as an additional gift. Lots of fiddly rules around it.
Got it. Mutual wills. This sounds like an agreement between two people making wills.
It is, usually spouses or partners. They make wills in similar terms based on an agreement between them that they won't revoke those wills after one of them dies.
So the survivor is bound by the agreement?
Yes. If they change their will after the first person dies, equity imposes a constructive trust on their property to give effect to the original agreement. But the key is proving that agreement not to revoke. It needs to be a clear, binding agreement, not just making similar wills. Child Birch v. Curtis.
More than just a hope or understanding, needs a contract, essentially.
Effectively, yes.
Yeah.
The courts are stricter here than with secret trusts because it binds the survivor's own property, too.
Right. Okay, finally, accessory liability, knowing receipt, and proprietary estoppel, holding non-trustees accountable.
Exactly. Accessory liability, or dishonest assistance, is where a third party dishonestly helps a trustee commit a breach of trust. The focus is on the accessory's dishonesty. Royal Brunei Airlines v. Tan. They become personally liable.
And knowing receipt.
That's about receiving trust property, or its traceable proceeds, knowing it came from a breach of trust. The question is whether the recipient's knowledge made it unconscionable for them to keep the property, Hillsdown Holdings. If so, they might hold it on constructive trust.
So catching those who helped with the breach and those who received the proceeds. And proprietary estoppel, stopping someone going back on their word about land.
That's the essence. It prevents a legal owner from unfairly denying someone an interest in property if the owner encouraged them to believe they had or would get an interest, and the person acted on that belief to their detriment.
Like building on someone's land because they promised it to you.
Classic example. The court then has flexibility to award a remedy that does the minimum equity to do justice, maybe granting the land, maybe a right to live there, maybe just compensation, Taylor fashions. It depends on the specific facts.
Wow. Okay. We have covered a lot of ground today, from equity's historical roots, patching up common law, through all these different kinds of trusts, secret, constructive, and then these powerful remedies and doctrines.
It really is a journey, isn't it? From that initial idea of a gloss on the law to this incredibly complex and nuanced system that impacts so much.
I think the core idea that really sticks is that flexibility. Equity's ability to step in where strict rules would lead to unfairness, to prevent people acting, unconscionably.
Absolutely. It's really a testament to how our legal system tries to evolve, to adapt its understanding of justice over time.
So what does all this mean for you, listening? Well, think about how many everyday things, buying a home with a partner, giving to charity, maybe even relying on a promise someone made about property, rely on these centuries-old ideas of fairness from equity. Even if you don't see the words trust or equity, those principles are often working silently in the background.
The hidden hand, ensuring a degree of fairness.
Which leaves us with a thought, doesn't it? In our world, which is only getting more complex, how do we make sure our legal frameworks stay flexible enough to deliver real justice, like equity aims to do, without completely losing the predictability that people need to rely on the law? Where's that perfect balance?